information of the company. Let's focus on company of the legal as well as financial diligence. So legal diligence include review of all the compliance of regulations, laws, and it's for a review cycle. There is always a review period, which is mostly of 2 to 3 years. It's not that if the company is 15 years old, so you need to review entire 15 years. Not possible. Financial mean you need to review the financial statements, include profit and loss statement, balance sheet, etc. And tax diligence, whether all the tax compliances have been done as per statutory requirement. Then we will draft documents SSA, SP, and SHA. And is it clear till now? समझ आ रहा है? Clear? Okay, got it. Just a minute, I am explaining. My screen and I believe Shifa, all the slides have been shared over email to you, the PPT and the draft, so you can circulate that as well in the WhatsApp group. Please share it in the WhatsApp group also. They can also
Sir, it's
open.
already done. It's already done, sir.
So I request the audience to open that in your mobile phones or your laptop. No, no, not possible in a slideshow. Otherwise, it would create problem for coming back to the Windows. So I don't prefer slideshows. I request you to please download those materials in your mobile phone or in your laptop, so that you can also open the slides. So that because otherwise you will not be able to understand a single thing. Because this is a very high profile session, I'm telling you, it took me 2 years to understand. So for within 50 minute session you will not be able to understand. So I request to download, and those who have downloaded, please post a message in the chat box, downloaded, so that all will also download if one will download. And yeah, so this is the slide second. Please open. Let me check how many of you have downloaded. Yeah, thank you so much. We are in this. I will explain you, and if it happens, the session extends for next 15 minutes. I will request the organizing committee to extend, but I will explain all the drafts properly so that you all will get the idea. Now that these documents will come, SPA, SSA, and SHA. These are very important documents for any transaction. If these are not properly documented during the closing stage of the transaction, the deal will not happen. It will fall away. Parties will step away from the deal. After the signing off, condition precedents will come. So condition precedents are the particular action which needs to be fulfilled before closing of any deal. Condition precedents means all the board resolutions, shareholders resolution have been obtained, all the filings have been done, company have done all the DMAT filings, there is no material adverse effect. Like, what is material adverse effect? So material adverse effect is a type of event that should not happen, which are negative events, which should not, these events which impacts the image of the company, which impacts the finance business of the company, and investors feel that if we invest in a company, these events will lower the value of the investor. What's the purpose of the investor? Investor's purpose is to ascertain what is the valuation today and what's going to be next 5 years. Because VC funds, which are SEBI category AIF funds category 1, are, I advise mostly smaller startups and all. So they focus on, they are financial investors, not strategic investors. Strategic investors focuses on collaboration, but the financial investors only focus on money. Though they will take little governance role to ascertain whether company is following all the conditions prescribed as per these transaction docs. Once these are fulfilled, then the shares will be the money will be wired, means money will be transferred to the company's bank account. Once the money comes within 60 days the shares will be transferred to the investor's demat account as per private placement section 42. So if it does not happen within 60 days, then next 15 days the company have to refund the money along with 12% of interest. And then the closing governance will take like updation of statutory registers, all the filings with ROC, etc. So each document plays a key role in structuring the transaction and allocating risk. Now I will take one question, then I will begin. Any doubt? Any doubt? Nothing. So let's begin the third one. Role of term sheet. Let me open the draft. Is the draft visible? Shifa? Yes.
Yes.
Is it?
Yes,
Yeah.
sir. It's visible.
So page number one. Open the page number one of the PDF. Open page number one. Demat account means nowadays no physical transfer of shares will happen. All will happen virtually. So for your understanding, learn it's a virtual way of transferring and issuing of shares. The which section you mentioned, section 42 of company said, I am slow only. Actually, Mitali, if I go very slow, it will take almost entire day to complete. So we have a limitation of time. So I have to accordingly proceed as per organization's rules. I hope you understand. You can ask the query, but I can't be slow itna ki it will create problem for everyone to attend for next 5 hours. Okay. Now comes your term sheet. So term sheet is a document which discusses the understanding. Guys, term sheet is a very important stage. What is agreement? Agreement is the mutual understanding between both the parties. They are on the same page. And this is something is term sheet for any acquisition or investment. Both the parties should be on the same page. It helps the parties to outline key commercial terms, drafting of definitive docs, provide the framework for DD. Like I mentioned, review cycle. No one asked this question, so I am even creating the question for you to even ask next time to any legal professional. Why term sheet is necessary for DD? Because then only party will decide how many years of DD should happen, what is required in DD, how many chapters needs to be covered. Everything is decided between the parties, and all depends on the budget of the company. Let's say if the company is newly incorporated, they don't have a budget to go for a lengthy DD. Then they will go for a smaller DD. It's not a statutory requirement to go for DD. It's a contractual requirement, and mostly all the provisions are non-binding and special exception confidentiality and exclusivity. Okay, now this is the structure. Guys, this whatever documents you all have in your mobile, these are something helpful during your day zero placements, during your CS exams, during your in-house counsel jobs, everywhere. Never delete this PPT and this draft. It's useful for everyone. Save it in your laptop also. Organizing committee has already circulated. I circulated it in advance only, so that my audience will get an opportunity to use it during your day zero preparation. Okay. Now term sheet contains what are parties, transaction structure, what is going to valuation. Now I just want to know if you do chat GPT and explain to us what is pre-money valuation and post-money valuation. Use chat GPT and someone use in answer it in chat box. Let's make it interactive. What is pre-money valuation and post-closing valuation? Why investor wants pre-money valuation? And who ascertains register valuer? As per section 247, note it down. Register valuer always ascertain the valuation of the company as per section 247 registered with IBBI regulations 2017. So what is pre-money valuation? Post it in chat box. And post money valuation, not post money valuation means post transaction valuation. Anyone volunteering, or should I do it from chat GPT and answer? Because I want to explain you. I request Mitali if you only type. Okay. Got it? So Sam Cyron has already mentioned. Pre-money means what is the existing value of the company basis the assets and IP and potential. The registered valuation through two methods. Note it down. First is discounted cash flow method. Discounted cash flow method. Second, net asset valuation method. So this asset one will be used in the NAV method. And discounted cash flow never ascertains the valuation of company through assets. This just learn it by heart. The difference between two methods. And post-money valuation means once the investment happened in the company, what's going to the valuation of the company? It's not just for 1 year valuation. Let's say after 5 years investor wants to exit. So 5 साल का वो लोग ascertain कर लेते हैं. They ascertain after next 5 years. Sorry for using Hindi. Sometimes if I use Hindi, just remind me because many of you not able to understand, those who have a linguistic barrier. So just tell that you are comfortable with English. Got it? Clear? Just type yes or no. Clear? Don't do thumb. Post it in chat box. Yes. Okay. Now this is investment amount, how much you are going to propose and how where the funds will be used. Yeah. Due diligence, which I have already explained. CP I have covered. So learn by this is something you need to learn for your interviews. Condition, this is something you should learn. Condition precedents are the important actions which needs to be ascertained before completion of closing of a transaction. So completion or definitive agreement means SPA, SSA, SSA should be completed. Governance right. You need to understand, let's say you are an investor, you are proposing 15 crores, let's say as per the template. You will ask for seat. That should be a consideration. You are paying, so what you will get in return? So consideration is an important mechanism in this. And you will say, sir, you are getting shares. No one will be satisfied with shares. They will ask for a seat to ascertain the control of the company, to see, because to have a vigilance over the affairs of the company. Let's say if the company is not following the rules, so there should be officer in default as per clause 247, I think. So they are there to see whether all the appointments, statutory appointments are done or not. Yeah. Exclusivity is very important. Let's say I volunteer for this session with this organization, Law Jurist. So now they can't ask someone else to come in my place because I have committed, they have committed. So this is exclusivity clause. Even in the oral agreement, they can't. Unless I postponed last week because I was traveling. But today I took, so exclusivity clause will still prevail unless agreement is not terminated. But exclusivity clause will not be applicable post termination. But non-solicit and non-compete clauses will be applicable. So let's now do a research on this. What is non-compete and non-solicit clause? I am typing someone please volunteer. Non-compete, non-solicitation clause. Guys, I am telling you, whatever I am teaching you will not be taught in your college. This is something no one even taught me in my profession. This is something I have learned, understood from the practical experience and reading lot of law firm articles, books. I use Textman book. I'm telling you, purchase that book, read the articles, read the sections. You will get the gist of company law. Those who have, I have a passion for this subject, and I have took lot of sessions in my career. So this will help you. Deepti, don't ask the questions which are not relevant to the session because we don't have a time. We have just large 40 to 45 minutes. So I hope you understand. We stick to the session requirement. So non-compete clauses are the restrictive covenants that you are not supposed to undertake the such particular business when you are part of this agreement. Post termination also for next 2 years, which are not enforceable by court, but in general, in during earliest VC venture capital deals, founders agree. Non-solicit means you can't poach any firm's employee if you have left. Got it? Now you answer, Deepti. I am taking your question. How to lawyers ensure that contracts is legally enforceable when both the parties agree on the same mutual terms and conditions, and all the safeguards have taken place like indemnity and damages to make sure the contract is risk free. Got it? Is it clear? ठीक है? The book name is Taxman. You purchase Taxman commentary. I recommend my audience to purchase this book. Guys, I'm telling you, if you all are commentary, yeah. If you are relying on ChatGPT and AI, I'm telling you not be taught, you will not understand anything. AI cannot replace books. This is a wrong presumption. I am completely against relying only on AI. I use AI, but you have to read the books also. AI can be used for explanation, but AI can replace the entire company's head. You have to read the books by heart, understand the nuances of each section. Any book, any book of Taxman, latest edition. Now this is the role of term sheet. I hope my slides are visible. Please, someone use the mic and say yes, so that I'm sure you are able to understand. Confirm you are able to get the visibility of my screen. Yes. Deepti, I have covered term sheet. So I request you to read the draft. All the elements are there in this. So term sheet captures the objectives. I covered outline transaction structure, defining valuation, investment amount, recording pre-commercial rights, providing a framework for definitive agreements, which we have covered. Now comes to a definitive agreement. What is share purchase agreement? So share purchase agreement governs the transfer of existing shares from seller to buyer. So the key features are transfer of ownership of shares, purchase of payment of purchase consideration. It's very normal that if you are getting the share, you will have to pay the money. Allocation of risk through reps and warranties. I'm going to explain indemnification for undisclosed liabilities. So what are reps and warranties? Anyone knows? Have read Contract Act? How many of you have read Contract Act? How many of you have read Contract Act? Please type read, READ. Please type read, those who have read. Okay. Now explain the difference between reps and warranties. Representation and warranties. Use ChatGPT or any AI and type it in chat box. What are reps and warranties? Reps. Just a minute. Let me type. Reps, warranties, and covenants. I will explain. Difference of three, and also what is misrepresentation. These four terms. Use ChatGPT and prepare the answer. So answer is come. So in general, Deepti asked for risk allocation mechanism. So reps and warranties is one of the risk allocation. You are representing, you are giving the statement that this statement continue to be true even in the past, present, and future. You are giving the some sort of statement which induces the other party to enter into a contract. Let's say the company is duly incorporated. So you are investor, you are thinking, oh, companies fulfill all the laws. Let's invest in the company. Covenants means the some sort of promise which you promise not to do or promise to do. In the pre-closing, post-closing, positive covenants, promises to do, like compliance, promise not to do, not to undertake any loans. So this is the difference. What are indemnities? Indemnity means the promise to indemnify, promise to compensate for any loss, predefined losses happen to other party. Maybe due to the conduct of the promisor or promisee, third party actions, direct and indirect actions, anything. All direct and indirect losses, future losses are covered under the loss definition in the shareholders agreement, in the share subscription and share purchase agreement. Indemnity is always in the share subscription and share purchase agreement because it relates to the investment amount, not relating to the investors' rights. This is not a right. This is a remedy. So rights will be covered in the SHA. Remedies will be covered in the share subscription and share purchase agreement. And the shareholder, all the company also gives reps and warranties. Promoters also founders, but investor will also give the reps and warranty only limited to the business very basic warranty, like they have all the they are legally qualified, means they are not disqualified under law to enter into agreement, like this minor is not allowed to enter into agreement. So they are, because it should not be below 18 years, and investor have taken all the resolutions, all the applicable statutory resolutions for entry into this agreement. That comes into share purchase agreement. For share subscription agreement, and because share subscription agreement means you are issuing the new security, not transferring the existing securities. So in that case, company gives the corporate warranties related to company's establishment and related to company's information. But since the company is run by the human agency, which are founders and directors, so they have to give all sort of business and other fundamental warranties. Even in the company's warranties, founders also have gives joint and several warranties. Several they give joint and several warranties, so that in case so that both of them are liable. But do you think that founder will always give the indemnity? In every case, no. There is a limitations which I'm not going to teach, which something goes beyond your head. So there are certain sort of limitations, safeguards, because we represent companies, not investors. So we have to think for the company, because company ko chalana hai, so we have to give some sort of limitations for the investors to ask for indemnity claims for every claims. I hope something it's clear. Now, misrepresentation means a false statement of facts. You're making the misrepresentation of something, which induce them to enter, but later on comes out to be false. So that the agreement is void. But in that case, agreement will not be void. They will ask for indemnity. So now let me open the draft share purchase agreement. We have last 30 minutes, so let me walk through fast only. So first comes the party's name, sale and purchase of shares. What is the price? I have covered. Closing mechanism. Read this section 56 on your own when you are free. Read this. Deepti, I can't take up the off-topic questions today. I'm really sorry. So please keep it relation to the section. I have to complete this session. Read it for your interviews and all. And read this. If the transfer is happening from existing shareholder to the new shareholder, read this. Reps we have covered, indemnity we have covered, confidentiality governing law is governed by laws of India. Now we should cover what is confidentiality. Can anyone explain what is confidentiality clause? Without using ChatGPT, just explain to us what is confidentiality clause. Now I want to ask some random student. Vedant, are you there in the session? Actually, you can't speak. So use chat box. What is confidentiality clause? What is confidentiality clause? What is confidentiality clause? Use chat box. Have you ever never signed even any agreements? So Godia Tiwari is already answered. So this is confidentiality. Nothing to explain. Any doubt till now? So we have two more drafts to cover, then we will complete the session. Any doubt? How can a normal person identify risk clause before signing? The risk clause are liability claims. If you are asking double the amount, but you have paid, but the liability amount, it should be specific to the loss. You can't ask for extra amount, which is penalty, as per section 73 of the 74 of the Indian Contract Act. Go through and read 74 penalty. Any doubt apart from Deepti? Anyone else? No doubt? Clear? So type yes. Clear? Yes. Type in chat box yes. It's where I am explaining a very simple language. Yeah, secret information, yes. Okay. Now let's go walk through share subscription agreement. So share subscription is opposite of share purchase. Now you are issuing the new shares, not transferring from by the company to investor. So it regulates subscription of new shares, investment amount, which I explained, CPs we have covered, and issuance allotment of shares. Assets are commonly used in VCPE investment where investor subscribes to new security issued by the company. This is very basic. Now come through this slide. Open slide 7. Those who are following the session, open slide 7. This is slide 7. Okay. So these are the very common clauses: purchase or subscription, consideration, CP, reps, covenants, closing mechanism, indemnity. So these are there in all the drafts you will find. Now let me explain SSA. So it will be helpful for you during your interviews also. So party's name will be there. Acha, what are recitals? Let me explain. Time for DD is almost 2 to 3 years, depends upon how the parties decide, Vaishnavi. Now, what are recitals? What is recital? Can anyone answer in the contract? What is recital? Without using ChatGPT also, if you have read the contract, what are recitals? Yeah, it gives you the background or transaction information. Okay. Then comes your private placement. Section 42. Guys, please read for your interview. Note it down. This is very important. Please open your notepad on something, copy diary, register. Section 42 of Companies Act. I'm not typing. Everyone have to write in your notepad so that you all have it record. Section 42 of Companies Act. Written, type written, type written. WRITTEN. Those who have written Section 42. Okay. Only one person have written. Okay. Read with Section 62 of Companies Act. Wrote down Section 42. Read with Section 62 of Companies Act along with Rule 14 of companies prospectus and allotment of securities rules. Prospectus and securities rules 2014 and Rule 13 of share capital and debentures rule 2014. Written 42, 62, Rule 14 and Rule 13. This is the Bible. This is the Bible. Can anyone type it in chat box for everyone? This is the Bible for share purchase and share subscription agreement. Rule. Those who have written, please type it in chat box for everyone's help. Mitali, if you type for everyone, Rajesh or anyone. Then subscription amount and CPs we have covered. Closing means when the subscription amount is received and shares are allotted. I have already answered this. Section 42(6) of this. Money should come within 60 days. Open page 7 of the draft. So second line you will have the idea. Okay. Covenants we have covered. Indemnity governing law we have covered. So this is something we have covered. This will give you the. So this is something the reps company gives. Duly incorporated company has the authority to issue shares and free from encumbrances. Okay. Now the last draft is, which is very important, shareholders agreement. Any doubt till now? Use chat box and ask. Any doubt? No? Because we are going to end by 7 only. It's going to be within 15 minutes. Yeah, thank you so much, Mitali. Now comes the last, shareholders agreement. So SHA governs the relationship of the shareholders within the company, one rights of the obligation of shareholders on the company once the investment is received, post closing actions, closing rights and all. So rights include or typically cover board composition and governance, transfer restriction, exit mechanisms, reserve matters, tag and track. It ensures long-term governance and protection of investors' right. Now comes your governance and investor protection. This is I have already covered. So Deepthi, you asked about how the risk allocation. So this is the slide for you to understand. Slide 8. You can open slide 8 in your mobile or laptop or iPad and open and read. Okay. Now let's discuss then, and then I will go for SHA draft. So what are the common drafting and negotiation issues? Valuation and pricing. How much valuation companies having investor will accordingly spend the money will give the money. Wraps and warranties, indemnity caps and limitations, which I told you. There will be limitations. Investor control rights like reserve matters. There are reserve matters are those matters which needs affirmative approval of the investors. Their yes should be there. Then only the resolution will pass in the board meeting. And exit mechanism, how the investor will leave after 5 years, 6 years, 7 years. So common exit mechanisms are IPO, strategic sale, merger and acquisition, strategic sale, or it's drag along rights. Conclusion will go in the end. And this is a draft. So this is a company's party's name, definition clause, shareholding structure, typical shareholder, what's going to be structure post or pre-closing, board composition. Section 152 talks about appointment of directors. For your ease of reference, I put all the sections also. Reserve matters I've already explained, the investors' consent like issuance of new security, borrowing, exceeding, sale of major assets, amendment of charter docs. Charter docs, note down section 10 of Companies Act, MOA and AOA, Memorandum and Article of Association, section 10, approval of annual business plan. Information rights are quarterly financial statement, audited statements, business updates, all the information relating to companies affairs. So section 129 talks about the financial statement which I told you. So transfer restrictions, section 58, you cannot transfer without articles amendment and all, because articles governs the affairs of the company. SHA cannot override AOA. AOA will prevail over SHA. Now comes your few rights which all of you knew. Rights of first refusal. So instead of issuing first, instead of, even if you have a third party offer, let's say the founders wants to sell the shares, they first should offer to the investor. And if investors agree, then you can sell them or you can sell to third party at the same price and conditions. But that's not in the case of ROFO. You first offer to the investor. The here issue is investor has to propose the price, but in the ROFR the market price is already calculated by the third party, so investors just have to pay the money. Here they have to calculate, so they always prefer ROFR. Tag along means if founder is selling the shares, so investor can also tag along, can also sell the shares in the same terms and conditions. Okay. Drag along, you can drag them. Can drag along means you can drag all the shareholders out of the company and provide a clean cap table to the new investor. Anti-dilution means if you are issuing the shares at a lower price, then the existing investors will get the price, get the new shares at the mechanism, which are, there are two mechanisms noted down. First is full ratchet method. Full ratchet. I'm typing this for everyone. Note it down, please. Full ratchet method. RATCHET. And second is weighted average method. Spelling is wrong, so just dekh lena, please. Weighted average method. Then exit rights, I have already explained. Deadlock. In case of deadlock, then refer arbitration, negotiation, mediation, confidentiality, indemnity cover, dispute cover. So we have covered everything in this. Now coming to the last slide of for the today's session. Conclusion, we will take a Q&A. Any question, any doubt. So you should have clear understanding allocation of risk, transaction structure, investor rights, legal requirement. The transition from TS to SSA, SPSHA depend on the process which commercial intent is converted into legally enforceable agreements. Thank you. So we have covered everything in today's session. Now I want to have a Q&A session. So we have 16 minutes. So you can ask any query. Any queries, so please let me know. No doubts, everything clear.
Guys, if anyone has any question related to the topic, sir just explained, please ask in the chat box.
Yeah, please type it in chat box. And I request to share then the form also, so that So no doubts. So I presume, please, for career prospectors, I'm taking this question, which is more important now. See, you can make career. You can make the career. I'm taking this question only because let me explain you how to build a career and what's the field of commercial sector, which is important now. So commercial sector is not related to, not restricted to this field. It's very huge. FEMA, FCRA, company set, SEBI, RBI, there are lot of sectors and lot of regulators. For this field, I request you to first of all read the book. I'm telling you, if you're getting any opportunity, it doesn't even matter if you're in tier 1 law firm, tier 2, tier 3, tier 4, doesn't matter in long run. Only matters your understanding. Like you have seen, I have covered within 40 minutes the entire draft because I read this draft on a daily basis. You will find this draft online. Just Google shareholders agreement PDF, double inverted comma and right and left. You will get. Go and copy paste in chat GPT and understand. Once you understand, please purchase the Taxman book. I have a Taxman book. I daily read that book. So this will give you the overall understanding. So please purchase a Taxman book, the commentary. Because if you want to build a career, you should be well versed with the application of law. Right. Secondly, read MCA updates, Minister of Corporate Affairs update. Now the Companies Amendment Bill 2026 have come. How many of you have read that Companies Amendment Bill 2026? I am not taking more questions. This is the only question because we are running short of time now. You can Google it and you will get all these answers. Let's focus on career and your information, how to build a career. That will give you the gist. How many of you have opened the Companies Amendment Bill 2026, which is now forwarded to the Joint Parliamentary Committees of Parliament? JPC को चला गया है वो bill. How many of you read? Others, the recordings will be circulated in the YouTube. So you will watch the session, you will get the idea. So please read the law, read the sections, do write publications, attend conferences, you will get idea. For due diligence, Mitali, for due diligence, it's a very lengthy process. It takes years and months to complete. So right now, just understand it's a review of the information at your level. Don't need to go into detail a lot of chapters. I don't have time right now to explain all the chapters in detail. So I've almost covered the important. These are law specific questions. Right now I don't have time. There's 58 and 56. So I also have to read in detail because I'm not a like a book. I also have to read. So apologies, I can't take up the law with specific sections because today's section is not related to its law, related to drafting and agreement. I have to read. I'm very honest and transparent. If I am not sure, so I'm like, I'm not sure, I have to read. Yeah, NDAs are applicable in everywhere. Let's say if you are in working in a government company. So if you are a government company, you cannot, you should not, you have to sign because they are concerned. They are more concerned than us. The information. So NDAs are applicable everywhere. Even if you go to internships, you have to sign the NDAs. How many of you have signed NDAs in internships? How many of you? Type yes. Those who have signed. Yeah. If you not sign NDA, All everything is data. Without data, you cannot function. And I'm sorry, I can't take law specific question because I have to read law. So 42 clause 6, I'm not sure of all the sections, but 42 is of private placement along with rule 14 of companies private prospectus allotment security rule. So you have to Google it. Any other doubts related to career or something? Last doubt I'm taking. Anyone or everything clear? Now there are a lot of agreements. I've just prepared a basic templates. Use them for your interview, guys. I'm telling you, use my draft and slides for interview or interview will clear. It's very basic. I have even included the sections. You have to learn those sections. You don't need to go into detail. It's no, don't have time because college you have a lot of commitments. So we as a lawyers also understand. And guide ka I have explained, Mitali, you have to read the books, you have to read the articles. Even those who have college textman subscription, read the articles. You will get text guru articles are also very good. Very good. Gaurang Singh, your questions, these questions are not relating to sections. So something I'm not the lawyer or the activist. So I don't have any answer for this question. So you ask the question specific to the session in case you have. Private placement, guys, you have to read the section 42 in details. We have to identify 200 investors, then board and shareholder approval will be done. Then the PAS4 offer letter will be circulated to them within 60 days of receipt of within the 60 days of receipt of amount. The shares should be credited to the demat account. After that, the PAS3 filing will be done to the ROC within 30 days of the allotment of security. This is the entire 42. मुझे तो रटा पड़ा है. I have know everything, but I can't explain one by one. It will take entire day. It's a very long process. I hope it's clear, Rajesh. Entire draft I have prepared. I know everything. Slides है ना मुझे रटा पड़ा है because मुझे तो रटा पड़ा है because डेली पढ़ता हूँ मैं ये सब जो मैंने आपको पढ़ाया आज. In real practice, focus on and observing things, how drafting takes place, how seniors draft. Then only you will get the idea, Gaurang. That reading textbook will not alone make you a lawyer. Practical experience along with theoretical knowledge makes a best lawyer. That's what I have understood within 2 years of my professional journey. Taxman, purchase any book. Even Avtar Singh is good. Purchase Avtar Singh. This is good. Now feedback in feedback form in chat box also. How is today's session? Feedback. How is today's session? Feedback in chat box. I want honest feedback, please, guys, because I spent a lot of time for preparation for the slides and draft. I'm telling you, and I was reading this draft for last 5-6 days for preparing your session. And apologies for postponing your session last week. I was traveling. Thank you so much, and thank you so much, Aayush and the team for inviting me for today's session. And and honestly, I am just a 2 years PQE career lawyer. I also am learning and understanding, but I took some time from my busy schedule and Aayush gave me the opportunity as well. Thank you so much. And I prepared the session within 40 minutes. Within 40 minutes, I have taught you the entire topic. So this is something I hope it's clear. I will try to take more sessions in the coming months, but we'll see. Gaurang, it depends upon the from person to person. Those who are interested will take the session seriously, and those who want to take certificate, let them be. It's particular person's choice. So it's depend on person. Like you are taking session, you are taking a session on a like your understanding. So it's good for your career. So let's everyone decide their own course of action. This is my answer to you. Thank you so much, guys, for the feedback. Over to you, Shifa. Thank you so much.
Thank you so much, sir, for sharing such a valuable insights. And the concepts were very simplified, and even I was also very intrigued, and it was very interesting, sir. And I would like to extend my sincere gratitude to Ayush and the entire Law Jurist team for organizing this session. And a heartfelt thank you to all of the participants for joining us today and making this webinar a success. We hope you leave this session with better clarity, practical understanding, and confidence. Lastly, we request all participants to kindly fill out the feedback form who have not filled it yet, because it is mandatory for receiving your participation certificate. Thank you once again and have a good evening ahead. Thank you so much, sir, once again. Everyone can leave now.
Thank you so much, guys. Thank you. All the best for your future endeavors.